let's start here. You've got illegal immigrants. You've got legal immigrants. You've got refugees, aka rapefugees. Okay, let's start here. What do we have? What does the United States recognize? Actually, you know what? Let's start here. U.S. recognition. Or United States law. Let's start here. That's a good place to start. Who deals with immigration? United States. I think it falls under a few different federal offices depending on if you're talking about like enforcement, processing, like there's a whole bunch of different, I think. Okay. The involved bodies. U.S. Citizenship and Immigration Services. USCIS. Whoops. Do you PTSD from green card process for Mel? I mean, it was annoying as fuck. I'm gonna say PTSD. Okay, the U.S. Citizenship and Immigration Services is responsible for processing immigration and naturalization applications and establishing policies regarding immigration services. Okay. U.S. immigration law. Wait. Hold on. Let's try here. There's more people are involved. You cannot access the site due to security restrictions. Your IP address has been blacklisted by one or more blacklists. Okay, well. Thanks. U.S. immigration law is based on the following principles: the reunification of families, admitting immigrants with skills that are valuable to the U.S., economy, protecting refugees, and promoting diversity. This fact sheet provides basic information about how the U.S. legal immigration system is designed and functions. Oh, cute. Well, this is a helpful outline. U.S. immigration law is based on the following principles. Let's see. U.S. law. What would I even put this under? Immigration. I hate this. I don't like this. Why is this all like cringy shit? Give me something more edgy. Quiet solitude. Is this edgier? Immigration goals. We've got the reunification of families. We've got admitting immigrants with skills that are valuable to the U.S. economy, protecting refugees, and promoting diversity. Let's see, college, good sources for information. On some of these things, I feel like I was sticking. How did I do this? Did I put sources at the top for an event? Events. How did I do this? Sources, I did. Okay, at the top. Okay. And what did this look like? Okay. Let's go with that. Okay. September 14th, 2021. Is that what this was published? 2021. How about some Final Fantasy VII lo-fi? You know what? Based. Okay. Is there a way I can kill this sidebar? Yep, okay. U.S. immigration law is based on the following principles: the reunification of families, admitting immigrants with skills that are valuable to the U.S. economy, protecting refugees, and promoting diversity. This fact sheet provides basic information about how the U.S. legal immigration system is designed and functions. The body of law governing U.S. immigration policy is called the Immigration and Nationality Act. That's good to know. Legislation Relevant legislation. Wait, should this be top level stuff? This shouldn't be called immigration. This should be called US immigration, right? United States immigration. This should be involved organizations. Would you call a government body an organization? Like, is the FBI an organization? Involved agencies? Okay, that works here, I guess, yeah. Departments, that's a good one. There you go. Okay. The Immigration and Nationality Act. The INA allows the United States to grant up to 675,000 permanent immigrant visas each year across various visa categories. Jesus, just let them in. The construction industry needs workers because the younger generation is so goddamn lazy. All knob, slob, 4 sweaty Latin dudes to help me shingle houses. Okay, thank you. Grants up to 675,000 permanent immigrant visas each year. Across various visa categories. On top of those 675,000 visas, the INA sets no limit on the annual admission of U.S. citizen spouses, parents, and children under the age of 21. No limit on U.S. citizens, spouses, parents, and children under 21. Doesn't count towards the 675,000 permanent visas a year. On top of those 675,000 visas, the INA sets no limit on the annual admission. Okay. In addition, each year the president is required to consult with Congress and set an annual number of refugees to be admitted to the United States through the U.S. Refugee Admissions Program. Is that created by the Immigration and Nationality Act? Or, let's check. Refugee Admissions Program. Refugee resettlement is a durable solution for individuals with humanitarian protection needs who have left their country due to persecution on account of protected ground, cannot safely return home, and require permanent resettlement to a third country because they are unable to remain in the country where they currently reside. The U.S. Refugee Admissions Program accepts referrals for refugees determined to be particularly vulnerable and in need of the protection provided by third country resettlement. The program provides a pathway for resettlement to the United States under the Immigration and Nationality Act. Okay, so it does come under that. What do I call this? Programs or attempts to resettle individuals with humanitarian protection needs who have left their country due to persecution on account of a protected ground, cannot return safely home, and need resettlement in a stable third country. Okay. The U.S. refugee admissions accepts referrals of refugees determined to be particularly vulnerable and needed the protection provided by third country resettlement. The program provides a pathway for resettlement to the United States under the Immigration and Nationality Act. The INA defines a refugee as an individual who is outside their country of nationality, or if no nationality, their last habitual residence, and who is unable or unwilling to return to, and is unwilling or unable to avail themselves of the protection of that country because of persecution or a well-founded fear of persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion. This is going to be probably the definition that the United States uses then for a refugee, right? This is refugee definition. So this is pretty important. Important stuff I think we were doing is green. Destiny, why does it go from first to third country? What's the second country? The second country is like the country they're currently in. So let's say that I run away from Venezuela and I'm in Mexico, right? Well, I can't go back to Venezuela because of some persecution thing, but I can't stay in Mexico because it's not stable here at all. So I'm seeking resettlement in a third country. The first country is the one I'm fleeing from. The second one is the one I happen to be in right now. The third country is going to be the one resettling you, basically. We are committed to protecting those with specific needs, including women and girls, children, older persons, members of ethnic and religious minority groups, LGBTQI, what is I, intersex, persons with disabilities, stateless persons, human rights activists and dissidents, and others who may warrant permanent refugee resettlement through the USRAP. President Biden affirmed the United States' commitment to welcoming refugees by maintaining the total admissions ceiling in fiscal year 2024 presidential determinations on refugee admissions. When you're talking about U.S. fiscal years, is this January 1st to December 31st, or does it depend on the agency? 12 consecutive months ending on the last day of any month except December. Okay, well, fuck you. Does this go by government budget or starts in September? Biden set the refugee admission ceiling in fiscal year 2024 at 125,000. The same target Biden established since fiscal year 2022. And the highest target in several decades. His decision reflects the United States' long-standing leadership on refugee resettlement in the face of an unprecedented global displacement crisis, as record numbers of people around the world have been forced to flee war, persecution, and instability. Nearly 110 million people are now forcibly displaced, more than at any other time in history, according to the United Nations High Commissioner for Refugees, the UNHCR. 2.4 million refugees are now in need of protection through third country resettlement. For these refugees, resettlement in the United States represents the opportunity to start anew, to pursue a life of safety and dignity without fear of violence or persecution. The U.S. RAP reflects our history as a nation welcoming of immigrants, exemplifying a U.S. values-based foreign policy and serving as a beacon of hope for persecuted people around the world. It is an important, enduring, and ongoing expression of our commitment to international humanitarian principles to save lives and alleviate human suffering, as well as of our commitment to human rights, including freedom of religion or belief and freedom of expression. Critically, it remains a powerful demonstration of the United States' continued solidarity with refugees and the countries hosting them. The U.S. RAP is a vital foreign policy tool that advances U.S. interests and national security objectives, including rebuilding a system that promotes safe, orderly, and humane lawful immigration. Alongside robust humanitarian aid and diplomacy, resettlement helps promote stability in regions experiencing crisis, demonstrates U.S. responsibility sharing with affected countries, and facilitates U.S. negotiations on improved humanitarian conditions with host countries, such as granting access to legal work, education, and lawful status for the vast majority of refugees who remain in countries of first asylum and will never be resettled. Cooperation among U.S. government agencies, U.S. state and localities, private resettlement partners, the American public, foreign governments, UNHCR, and the International Organization for Migration make the U.S. RAP possible. Since the passage of the Refugee Act in 1980, the United States has admitted more than 3.2 million refugees. The Refugee Act in 1980. Of 1980? I might do something about this at some point. Okay. Involve departments and agencies. I'll just say bodies. And then we'll do domestic, and we'll do international. We've got the United Nations High Commissioner for Refugees, the UNHCR, and we've got the International Organization for Migration, IOM. I have never heard of that org in my entire life. Okay. Once a person obtains an immigrant visa and comes to the United States, they become a lawful permanent resident. Okay, remember a few days ago we were talking about whether a visa counts as an immigrant, so I guess this is the language used for United States immigration stuff. Okay, so we got legislation, immigration goals, involved bodies, immigrant types. I might axe this whole thing. I feel like I should have immigration process, maybe. Legislation, immigration goals, involved bodies, immigration process. Yeah, let's do that. Immigration process. Step 1. Obtain an immigrant visa. Step 2. Become a lawful permanent resident. Boom. In some circumstances, non-citizens already inside the United States can obtain lawful permanent resident status through a process known as adjustment of status. We'll sort this out as we read more later on about this. LPRs are eligible to apply for nearly all jobs, i.e. jobs not legitimately restricted to U.S. citizens, and can remain in the country permanently even if they are unemployed. After residing in the United States for 5 years, or 3 years under some circumstances, LPRs are eligible to apply for U.S. citizenship. It is impossible to apply for citizenship through the normal process without first becoming an LPR. Lawful permanent resident is that's what a green card is. I believe that is the green card. Let's see. Can apply for U.S. citizenship after remaining in the country for 5 years or 3 years in some cases. I think for the marriage one, I think you could do it in 3 years. Prerequisite for becoming a citizen. Did you use a K1 visa? Yes. Each year, the U.S. also admits a variety of non-citizens on a temporary basis. Such non-immigrant visas are granted to everyone from tourists to foreign students to temporary workers permitted to remain in the country for years. While certain employment-based visas are subject to annual caps, other non-immigrant visas, including tourist and student visas, have no numerical limits. So you could have tourism, students, temporary workers. You can file an adjustment of status to become a lawful permanent resident. Okay, I'll do this. Each year, the United States also admits... Oh, wait, we got this. Okay. Okay, 1. Family-based immigration. Family unification is an important principle governing U.S. immigration policy. The family-based immigration system allows U.S. citizens and lawful permanent residents to bring certain family members to the United States. Family-based immigrants are admitted either as immediate relatives of U.S. citizens or through the family preference system. Okay, so these would be immigrant visas. Immigrant visas. We'll have types. Then we'll have non-immigrant visas and types. The bridge burned with Pixie? No, I don't think so. So family visas. I'll just say family visas. Unlimited in number. An unlimited number of visas are available every year for the immediate relatives of U.S. citizens. Prospective immigrants in this category must meet standard eligibility criteria, and petitioners must meet certain age and financial requirements. Restricted to immediate relatives. Spouses of U.S. citizens. Unmarried minor children of U.S. citizens under 21. Wait, hold on. Unmarried minor children of citizens under 21. Parents of U.S. citizens. Petitioner must be at least 21 years old to petition for a parent. Well, okay. A limited number of visas are available every year under the family preference system. Wait. Okay, wait. So not all family ones are unlimited. For the immediate relatives of U.S. citizens. Okay. Oh, I fucked this up. I should have done. Okay, there. Wait. Why is this so weird now? Oh, fuck. I fucked this up. Okay, there we go. Okay, so these are visas restricted to immediate relatives. Okay, these ones are unlimited in number. And then immediate relatives are these three categories. Okay. Wait, how do I close this? I don't need this shit. Oh, there we go. Oh, I see. A limited number of visas are available each year under the... Okay, and then you have the... Okay. Family preference system. Prospective immigrants in the family preference system must meet standard eligibility criteria, and petitioner must meet certain age and financial requirements. Okay. To meet eligibility criteria. And then the petitioner must meet certain age and financial requirements. Family preference system includes adult children married and unmarried, brothers, sisters of U.S. citizens. Petitioner must be at least 21 years old to petition for a sibling, and then spouses and unmarried children, minor and adult, of lawful permanent residence. Okay. Does Obsidian work well with the iPad? I would say so, yeah. In order to balance the overall number, oh wait, these are limited in number. In order to balance the overall number of immigrants arriving based on family relationships, Congress established a complicated system for calculating the available number of family preference visas for any given year. The number is determined by starting with 480,000, the maximum number in principle allocated for all family-based immigrants. Okay. Jesus Christ. Limited to 480,000 for all family-based immigrants. The max number in principle allocated for, and then subtracting the number of immediate relative visas issued during the previous year and the number of aliens paroled into the United States during the previous year. What does paroled mean? Any unused employment preference immigrant numbers from the preceding year are then added to this total to establish the number of visas that are available for allocation through the family preference system. However, by law, the number of family-based visas allocated through the preference system may not be lower than 226,000. The number of immediate relatives often exceeds 250,000 in a given year and triggers the 226,000 minimum for preference visas. As a result, the total number of family-based visas often exceeds 480,000. In fiscal year FY 2019, family-based immigrants comprised 68.8% of all new lawful permanent residents in the United States. Jesus Christ. Parole just means admitted. Okay. Okay, so the number is determined, so you start with 480K, then you subtract the number of immediate relative visas, and the number of aliens paroled into the US, admitted into the US during the previous year. Is this like of all aliens, of all immigrants, or? Any unused employment preference immigrant numbers from the preceding year are then added to this total to establish the number of visas that are available for allocation. However, by law, the number of family-based visas allocated to the princess may not be lower than 226,000. Family-based visas. The number of immediate relatives often exceeds 250,000 in a given year and triggers the 226,000 minimum for perpetuity. As a result, the total number of family-based visas often exceeds 480,000 in fiscally. This is this is so cringe, or it's so complicated. There's a complicated formula for establishing the number of family preference visas allocated for any given year. I'm just gonna copy this here. Fuck this. 2019, in fiscal year 2019, family-based immigrants comprised 68.8% of all new lawful permanent residents. Okay. The family-based immigration system is summarized in Table 1. Do I need this table? I don't think I do. I don't think we care that much. In order to be admitted through the family-based immigration system, a U.S. citizen or LPR sponsor must petition for an individual relative, establish the legitimacy of the relationship, meet minimum income requirements, and sign an affidavit of support stating that the sponsor will be financially responsible for the family members upon arrival in the United States or adjustments to LPR status within the United States. The individual relative must also meet certain eligibility requirements that include submitting to a medical exam and obtaining required vaccinations, including a COVID-19 vaccine, an analysis of any immigration or criminal history, as well as demonstrating that they will not become primarily dependent on the government for subsistence. Okay, so then this applies to even immediate relatives, I'm guessing? Yeah, it must. Okay. Petitioner must establish. This is probably going to be for let's see. This is probably for everybody. That'd be my guess. Okay. Petitioner requirements. Establish the legitimacy of the relationship. Meet minimum income requirements. Sign an affidavit of support. Financial support. Relative requirements. We've got medical exam. Required vaccinations. Analysis of any immigration or criminal history. Not addicted to drugs. Okay. The spouses and children who accompany or follow the principal immigrant, the one sponsored by the U.S. citizen or lawful permanent resident under the family preference category, are referred to as derivative immigrants. Holy shit. Let's see. Types of family visas. Oh, this should get bumped by 1. Where did not addicted to drugs come from? As well as demonstrating they will not become... Oh, I thought this said dependent on substances. Never mind, I'm retarded. They shouldn't be addicted to drugs either, though. spouses, children who accompany or follow the principal immigrant sponsored by the U.S. citizen or lawful permanent resident are derivative immigrants towards the numerical caps for family visas. That means that many of the visa slots allotted for members of these categories are often actually used by the spouses and children of the members. For example, in fiscal year 2019, 61,031 people were admitted in the category brothers and sisters of U.S. citizens, but only 22,179 of them were actual brothers and sisters of U.S. citizens. The rest were spouses and children of siblings of the siblings of U.S. citizens. Okay. Okay, for example, in fiscal year 2019, okay, that's family visas. Wait, immigration visas, types, that's family. Okay. Types. We've got employment-based visas. The United States provides various ways for immigrants with valuable skills to come to the country on either a temporary or a permanent basis. Jesus Christ. Okay. Temporary visa classifications. These wouldn't be under visa immigrants though. Or I'm sorry, these wouldn't be, yeah, immigrant visas. Temporary employment-based visa classifications permit employers to hire and petition for foreign nationals for specific jobs for limited periods. Most temporary workers must work for the employer that petitioned for them and have limited ability to change jobs. There are more than 20 types of visas for temporary non-immigrant workers. These include L1 visas for intercompany transfer. Oh, Jesus Christ. Okay. Would I put these under non-immigrant visas? Oh God. Immigrant visas. I'm just going to call this visa categories. All family-based visas are permanent, right? Like, you're not going to be a temporary visa for, like, a brother or some shit, right? I'm guessing. Okay. Okay. Family-based visas, employment-based visas. Temporary. Temporary employment-based visa classifications permit employers to hire. Okay. Temporary work visas. More than 20 types of non-immigrant visas for temporary work. L1 visas for intra-company transfers. P visas for athletes, entertainers, and skilled performers. R1 visas for religious workers. A visas for diplomatic employees. O1 visas for workers of extraordinary, that's me, ability. H visas for highly skilled and lesser skilled workers. The visa classifications vary in terms of their eligibility requirements, duration. Eligibility, duration, and whether they permit workers to bring dependents and other factors. In most cases, these workers must leave the United States if their status expires or if their employment is terminated. In most cases, workers must leave the U.S. if their status expires or they lose their job. Is immigration a good replacement for birth rate dropping a bit low? Birth rate and immigration, I don't think have anything to do with each other. I would view these concepts as completely and totally different from one another. And it's arguable whether low birth rates or any of that are even a problem. That's a way bigger philosophical question that people just assume to be the case. The visa classifications vary in terms of their eligibility requirements. Okay, I don't know. If their status expires or their employment is terminated, it may be possible, depending on the type of job and the foreign national's qualifications, for an employer to sponsor the worker for permanent employment. A foreign national does not have to be working for the employer in order to be sponsored. However, depending on the permanent immigration category sought and the foreign national's current non-immigrant category, he or she may be able to complete the steps to become an LPR while continuing to live and work in the U.S. Possible to become a lawful permanent resident. Depending on type of visa, I guess, I don't know. Doesn't a low birth rate mean that the economy in the future will go to shit? A little. I mean, some things get better, some things get worse. It just depends. It just depends. Housing will get better and more affordable, right? Your economy won't grow as fast as it could because labor is arguably one of your most important inputs, but productivity for labor can continue to increase as it has in the United States. So, I mean, theoretically, the economy could continue to grow. Housing producers will produce less if they see lower population growth. They aren't stupid. They build around future demand, except the housing economy is not just supply and demand. It's also artificially capped by land. There's an absolute cap there that's not based on per capita, how many people live in the country. So. Okay. permanent immigration. The overall numerical limit for permanent employment-based immigrants. Oh, hold on. Employment-based visas. All right, temporary work visas. There's that. Okay. Permanent immigration. Isn't Social Security the big concern there? I don't think there are genuine Social Security concerns. I think that's like a meme, but I'd have to research more into it. Every time I've seen somebody do an actual write-up on that, it just seems like it's meme fear-mongering. For some category, okay, wait. The overall numerical limit for permanent employment-based immigrants is 140,000 per year. How do you support an inverted pyramid-style age demographic with a dwindling tax base and reduced economic consumption? Oh, true, you can't. I remember that from a Peter Zeihan video. Never mind. Okay. The overall numerical limit for permanent employment-based immigrants is 140,000 per year. Okay. Limited to 140,000 per year. Okay. Any unused family preference immigrant numbers from the preceding year are added to this cap to establish the number of visas that are available for allocation through the employment-based system. Jesus, this is so fucking complicated. Oh, this number includes the immigrant plus their eligible spouses and minor unmarried children. Meaning the actual number of employment-based immigrants. Okay. This number includes the immigrant spouses and minor unmarried children. The actual number less. Any unused family preference immigrant numbers from the preceding year are added to this cap. Okay. The total number of available visas is then divided into 5 preference categories. For some categories, the sponsor must first test the U.S. labor market under terms and conditions established by the Department of Labor, and the Secretary of Labor must certify that the petitioner's application meets certain requirements before the sponsor may file a petition with the U.S. Citizenship and Immigration Services, USCIS. For some categories, the sponsor's first step is to file a petition. Oh, so we're talking about, so the Department of Labor is involved here. We would put them under relevant bodies. Domestic. Department of Labor. For employment visas. For some categories, the sponsor's first step is to file a petition with USCIS, or the foreign national may self-petition. The final step is the foreign national's application for an immigrant visa at a U.S. embassy or consulate abroad, or an application to adjust status to LPR if in lawful status in the U.S. For consular processing, the immigrant visa application cannot be filed until after USCIS approves the immigrant petition. For adjustment of status, the time to file the application depends on whether a visa number is considered to be immediately available. The employment-based immigration system is summarized in Table 2. Let's see. Preference Category 1. Persons of extraordinary ability in the arts, science, education, business, or athletics, outstanding professors and researchers. Okay. Table of preferred immigrants. Oof. Can I put this under? This isn't going to work, is it? Oh my god, imagine if I copy-pasted this and it just worked. Imagine if it just copy-pasted perfectly. Oh, and it doesn't. Table, table, table. I mean, I don't really need a table, I guess. Fuck. Preferences for employment-based immigration. Persons of extraordinary ability. Members of professions holding advanced degrees. Skilled workers with at least 2 years of training or experience, professionals with college degrees, or other workers for unskilled labor that is not temporary or seasonal. Certain special immigrants, including religious workers. Did you download the advanced tables plugin for Obsidian? Very useful. I don't think it does anything. I think all of that is integrated now into Obsidian proper. $40,040. It's fucking weird ass stupid fuck numbers. 9,940 and 9,940. Try Windows S. Why? What the fuck does Windows S do? Windows S. Switches in and out of safe mode? Oh, Windows Shift S. Oh, you want me to take a screenshot? No, I'm good. In fiscal year 2019, immigrants admitted through the employment preferences made up 13.5% of all new lawful permanent residents in the United States. In fiscal year 2019, economic immigrants made up 13.5% of all new LPRs in the US. Why do I have percent? Oof, gross. Oh no, wait, what are we doing here? Don't be cringe. There we go, okay. Okay, so we've got family visas, we've got employment visas. Let's see, per country ceilings. What would this go under? In addition to the numerical limits placed on the various immigration preference categories, the INA also places a limit on how many immigrants can come to the United States from any one country. Currently, no group of permanent immigrants, family-based and employment-based combined, from a single country can exceed 7% of the total number of people immigrating to the United States in a single fiscal year. This is not a quota to ensure that certain nationalities can make up 7% of immigrants, but rather a limit that is set to prevent any immigrant group from dominating immigration flow to the United States. No group of permanent immigrants. In addition to that, from one country. Interesting. Okay. Okay. Okay, so visa categories. I'm trying to think. This isn't gonna look pretty. I don't care about that part. No group of permanent immigrants, family and employment-based combined from a single country can exceed 7% of the total number of people immigrating to the U.S. in a single fiscal year. Ugh, okay. Immigrant visa categories, that's what we'll call this. Okay. Oh no, fuck. Can you just make this 1, 2, 3? Never mind, I'll change it. Okay. Have you looked into the UFL Arab situation? Is the BBQ guy actually a cannibal? I don't know. Apparently cannibal stuff. Are you talking about the Haiti stuff? Some of that shit is wild. I was watching videos of people doing some crazy shit. Does Syrian girl live on Twitter, or would she actually have a conversation with you? No, she would not. I think she lives in Australia. Okay, refugees and asylees. I think we're gonna put this in a separate thing. Refugees and asylum seekers. Refugees are admitted to the United States based on an inability to return to their home country because of a well-founded fear of persecution due to their race, membership in a particular social group, political opinion, religion, or national origin. I think we had, this is listed up here under USRAP for refugees. Refugees apply for admission from outside of the United States, generally from a transition country that is outside their home country. Okay, let's check. Okay. opinion, religion, or national origin. Apply for admission from outside of the US from a transition country. It's outside their home country. That girl's in Russia right now? Is she actually? The admission of refugees turns on numerous factors, such as the degree of risk they face, membership in a group that is of special concern to the United States, designated yearly by the President and Congress, and whether or not they have family members in the United States. Okay. Numerous, or wait, hold on. Factors that determine acceptance. Degree of risk they face. Membership in a group of special concern to the U.S. Designated yearly by Congress / the President. Whether they have family members in the U.S. Destiny, she took a video outside what she claimed to be the mall that got shut up, and she was vlogging a bunch of in front of crying people. I wouldn't believe anything from her. Even if that video was posted, I need to see more. I don't think I would believe it. She's one of the worst actors on Twitter in terms of just... Did you see that tweet from today that I did the works cited crack pipe on? The quote tweet? That tweet that she had was wild. Okay. Refugee, okay. Each year, the President, in consultation with Congress, determines the numerical ceiling for refugee admissions. The overall cap is broken down into limits for each region of the world. Each year, the President and Congress set the cap for refugee admissions, broken down into limits for each region of the world. After September 11, 2001, the number of refugees admitted into the U.S. fell drastically. After the Bush administration put new security checks in place, annual refugee admissions returned to their previous levels and rose during the Obama administration. During the Trump administration, the refugee ceiling fell sharply, from 110,000 in fiscal year 2017 to 45,000 in 2018 and 30,000 in 2019. For fiscal year 2020, the ceiling was set at an all-time low of 18,000, although only 11,814 were actually admitted, the lowest number of admitted refugees since the system was created in 1980. The fiscal year 2021 ceiling was set at 15,000 by the Trump admin, but was subsequently raised to 62.5 by Biden. However, as of August 31st, 2021, only 7,637 refugees had been admitted, with just 1 month remaining in the current fiscal year. Probably because of COVID stuff, huh? Of the 62,500 admissions determined by the President for fiscal year 2021, the regional allocations are shown in Table 3 below. Given the slow pace of admissions, it's unlikely that any of these allocations will be met. Oh wait, that's just for 2021. 22,000 from Africa, 6,000 from East Asia, 4,000 from Europe and Central Asia, 5,000 from Latin America and the Caribbean, Near East and South Asia, 13,000, and then unallocated reserve, 12,500. I wonder how they, like, oh shit, refugee admission reports. XLSX file. What do you think this is? What is that? Is that like a spreadsheet or is it like a... This isn't going to open. I can't open that in a browser? Oh, that's an Excel. Oh, yeah. Well, is Excel not free with Windows yet? Import to Google Sheets? Bro, I don't want to do all that shit on here. Okay, okay, this is refugee and asylum seekers. Ooh, okay, these are refugees. Asylees. Asylum is available to persons already in the United States who are seeking protection based on the same 5 protected grounds upon which refugees rely. Available to persons already in the United States based on the same 5 protected grounds for refugees. They may apply at a port of entry at the time they seek admission or within 1 year of arriving in the United States. Does port of entry only mean like by like a port, like a boat port? Port of entry wouldn't include like ground crossings and stuff, would they? Port of entry, immigration. A port of entry is a place where one may lawfully enter the nation. Oh, so it does include road. Okay. Port of entry does include border crossings like that. Okay. There's no limit on the number of individuals who may be granted asylum each year, nor are there specific categories for determining who may seek asylum. Interesting. Why is that? Huh. No limits on the number of individuals who may be granted asylum each year, nor are there categorical limitations. In fiscal year 2019, 46,508 individuals were granted asylum. That's kind of interesting. Yeah, there's probably, I think there's like international weird shit about like, what is it, like stateless people or something? I don't think you're allowed to kick people out of your country if they don't have a place to go. There's some weird shit about that, I think. Immigrant visa categories. Refugees and asylum seekers, you wouldn't consider these like visas, right? Like a refugee visa, you wouldn't consider that that's not a thing, right? Whoops. Refugee visa USA. Okay. You would just do like what, like a status adjustment basically, or you'd be a refugee and you'd slowly adjust your status to lawful permanent resident? Okay, the diversity visa program. Immigrant. Okay, so we'll just call this immigrant categories. And we're gonna bump these guys all in here. Now, permanent group, both of these apply. This here applies to 1 and 2. Would I just put this at the bottom of 2, I guess? I guess I would. fuck? What's going on with this guy? There we go. 1, 2, 3. Okay. Okay, so at least, okay. In fiscal year 2019, 46,500. Okay. Refugees and asylees are eligible to become LPRs 1 year after admission to the U.S. as a refugee. Or 1 year. Oh, I see. Okay. Eligible to become LPRs 1 year after admission to the U.S. as a refugee or after receiving asylum. Makes sense. Okay. The Diversity Visa Program. Become a law. Okay. Refugees and asylum seekers. For people that have used Obsidian a lot, is there an easy way? So like, let's say right here on 3, I want to make like 4. But I've got to like scroll all the way down here and figure out where it is. Is there like an easy way to just, so like I would imagine one thing that'd be cool is imagine if I could like collapse this category and then push enter here, but I can't. I mean, it goes all the way down here and then I can shift back, but does anybody know what I'm saying? Is there a shortcut that I don't know? Shift plus tab. That's not at all. No. Okay. All right, that's fine. Oh wait, that time it worked a lot easier. Wait, why? Oh no, it's just fucked. Okay. So I hit enter and then I've got to do shift tab. That's what I have to do. Cringe. Okay, whatever. Okay, the Diversity Visa Program. The Diversity Visa Program was created by the Immigration Act of 1990. More legislation, okay. Is that different than the Immigration and Nationality Act? The Immigration and Nationality Act of 1965. Oh, this is the Hart-Celler, this is the one I researched for my Fuentes debate. Quick summarize the act? I don't remember. It's been a long time. But I think it was like the first formal legislation I think we kind of had for figuring out immigration or something, wasn't it? Pisco kind of talked about it when he was here last, but I think we kind of like did a lot of immigration on the fly or some like weird shit. Let me check. Landmark federal law, signed into law by Lyndon B. Johnson. The law abolished the national origins formula, which had been the basis of U.S. immigration policy since the 1920s. The act formally removed de facto discrimination against Southern and Eastern Europeans, as well as Asians, in addition to other non-Western and non-ethnic. Okay. I feel like, I think before this, before the Immigration and Nationality Act, I think our immigration system was like kind of haphazardly thrown together. I think that's my understanding, but I don't have a strong attachment. I might be wrong. Okay, we had the Refugee Act. 1980. Okay, and then what did we have? The Immigration Act of 1990. Immigration Act 1990. The fuck? Okay. Okay, we were here. The Diversity Visa Program. The Diversity Visa Program was created by the Immigration Act of 1990. It's a dedicated channel for immigrants from countries with low rates of immigration to the United States. Created by the Immigration Act of 1990. For immigrants from countries with low migration rates to the US. Is there a difference between like immigrate and migrate? Is immigrate like more specifically referring to like a legal process? Like if I were to say like I want to increase migration from countries or I want to increase immigration from countries, do those things mean the same thing? Or is it like, can you use them interchangeably, or does migrate just refer to like the movement of people and immigration refers more to the legal process? Migration versus immigration. Immigrate is to come from another country to live permanently. Migrate is to move like birds in the winter. Oh, immigrate and emigrate are both forms of migration. That makes sense. Okay. Migrants from. Okay. So if we were to say like a migrant from the United Kingdom, in the United States, there's a migrant from the United Kingdom. We would say that that is a US immigrant and it's a British emigrant, right? Okay. The Diversity Visa Program was created by the Immigration Act of 1990. It's a dedicated channel for immigrants with countries with low rates of immigration to the United States. Each year, 55,000 visas are allocated randomly through a computer-generated lottery to nationals from countries that have sent fewer than 50,000 immigrants to the United States in the previous 5 years. Holy fucking random shit. Okay. $55,000 visas a year are randomly allocated through a computer-generated lottery to nationals from countries that have sent fewer 50,000 immigrants to the US in the previous 5 years. Of the 55,000, up to 5,000 are made available for use under the Nicaraguan Adjustment and Central American Relief Act program, created in 1997 to provide relief to certain asylum seekers who applied for asylum before a specific date. Okay. More legislation. Nicaraguan Adjustment and Central American Relief Act. (1997). Listening to Greek God try and interact with Destiny XQC felt weird. Yeah, I don't understand what he was doing. I'm not sure. I don't know if his like brain has been melted by all like the self-help online masculinity red pill shit or what. I feel like he used to be able to have normal conversations, but it felt like he was like constantly trying to like make a joke or a meme and he couldn't engage in any part of that conversation like a human being. I have no idea. That was really weird. Okay, dude. 5,000 are made available for use under the Nicaraguan and Central American Relief Act program. Let's see. Hasn't that been your convo with him for years now? He was trying to trigger you, so you look insane. He didn't like you. I guess maybe, but like you should be able to like turn it on and off, right? The program was originally intended to favor immigration from Ireland. During the first 3 years of the program, at least 40% of the visas were exclusively allocated to Irish immigrants. Originally intended to favor Irish immigrants. Exclusively allocated to the Irish during the first 3 years of the program. Jesus Christ. Okay. To be eligible for a diversity visa, potential applicants from qualifying countries must have a high school education. Okay. Eligibility. Oh, not spelling the word eligible, hopefully. Okay. At least a high school education or its equivalent, or have within the past 5 years a minimum of 2 years working in a profession requiring at least 2 years of training or experience. Or in the past 5 years, a minimum of 2 years working in a profession requiring at least 2 years of training or experience. Spouses and minor unmarried children may also enter as derivatives. Immigration bans implemented by the Trump administration effectively shut down the diversity visa program in 2020 and left roughly 43,000 of that year's lottery winners without their visas. Those 2020 lottery winners who did not receive visas by the end of the fiscal year lost their chance to immigrate to the United States, prompting some of them to file lawsuits against the federal government in an effort to obtain their visas. Although the Biden administration subsequently lifted the immigration bans, the diversity visa program has resumed at a very slow pace. By the end of June 2021, the state government issued only 3,094 diversity visas for fiscal year 2021. Some fiscal year 2021 lottery winners have filed lawsuits demanding that the State Department issue their visas before the end of the fiscal year. Can you file a lawsuit against the United States if you're not a U.S. citizen? It's kind of weird. Like, who has standing for that suit? Immigration bans implemented by Trump admin effectively shut down program in 2020. And since resumed under the Biden admin, but at a very slow rate. Look, why is it so cringe? This should say 4. No, it shouldn't. Wait, I mean, this should say 4. Cringe. Okay. I'd love to see you bring on Brian Kaplan or Alex Norwaste to discuss immigration. I think I have access to Alex. I think somebody made him available to me. But I said I would talk to him maybe after I've done all my research. I've read a lot of articles by him, though, because he writes for Cato, I think. I've seen a decent bit from him. Okay. Other forms of humanitarian relief. Temporary protected status, TPS, is granted to people who are in the United States but cannot return to their home country because of natural disaster. Oh, okay. Let's do this. We've got immigrant categories. Is any of this permanent or refugee and asylum seekers? Would I stick this under refugee and asylum seekers? No, because this doesn't necessarily make you an immigrant. I see. We'll just stick this on its own thing then, I guess. Other forms of humanitarian relief. Okay. We've got temporary protected status, TPS. It's granted to people who are in the US but cannot return to their home country because of natural disaster, extraordinary temporary conditions, or ongoing armed conflict. TPS is granted to a country for 6, 12, or 18 months and can be extended beyond that if unsafe conditions in the country persist. TPS does not necessarily lead to LPR status or confer any other immigration status. Are all of these temporary? Doesn't lead to status, immigration status. Does not confer any path to legal status. Okay, okay. Temporary in nature. Granted to those in the US who cannot return to their home country due to natural disaster, extraordinary temporary conditions, or ongoing armed conflict. Granted for 6, 12, or 18 months. Ugh. I need to just be using numbers. Fuck, I need to replace every number in this document. The words with the number itself. 18 months, but can be extended if unsafe conditions persist. Deferred enforced departure. DED. Provides protection from deportation for individuals whose home countries are unstable, therefore making return dangerous. Unlike TPS, which is authorized by a statute, DED is at the discretion of the executive branch. DED does not necessarily lead. Oh. Is DED just a casual name then? Or does this refer to a particular... DED is in the president's discretion, authorized as part of the constitutional power to conduct foreign relations. Interesting. Holy shit, okay. Though DED is not a specific immigration status, individuals covered by DED are not subject to removal from the United States for a designated period of time. DED directive, we've got 2 for Liberia and for Hong Kong. Interesting. Deferred enforced departure. Okay, so provides protection from deportation for individuals whose home countries are unstable, making their return dangerous. This is authorized by statute. It's good to know. This is executive discretion coming from presidents, constitutional authority regarding foreign relations. I'm curious, where does that constitutional authority come from? Constitutional power to conduct foreign relations. President, USA. Article 2, Section 1. Okay. Clause 1. Cringe. Wait, where the fuck is the foreign affairs here? Do I have to keep going? Wait, am I retarded? Section 1, Clause 1.8. Wait. Term of the President. The President's foreign affairs power. Shut up. Article 2, Section 1, Clause 1. Article 2, Section 1. Where can I just see, like, the Constitution? The executive power shall be vested in a president. Oh, is this what it's referring to? The executive power, sorry. Shall be vested in a president of the United States of America, shall hold his office during the term of 4 years, and together the vice president chosen with the sum term be elected as follows. Or is that the extent of the president's foreign affairs power has been subject to debate since the early stages of the republic. The Constitution provides that the president shall receive ambassadors and other public ministries. In his commentaries on the Constitution of the United States, Justice Joseph Story noted, if the executive receives an ambassador or other minister as the representative of a new nation, it is an acknowledgement of the sovereign authority de facto of such new nation or party. In addition, Article 2 provides, oh, by the way, this thing here, this writing, funny because we can tie this into other history we know, right? Justice Joseph Story noted, if the executive receives an ambassador or other minister as the representative of a new nation, it is an acknowledgement of the sovereign authority de facto of such new nation or party. This is why I think for the Israel-Palestine stuff, or for the Israel Arab stuff, a lot of the people didn't want to lead with Israeli leaders because in a way I think it like de facto legitimizes them as the leaders of a country that they don't want to recognize as existing. My guess is if I did more digging into like the Taiwan-China shit, it probably has to do with why you don't recognize Taiwan and it keeps everybody happy, even though you kind of sort of do deal with them anyway. In addition, Article 2 provides that the President, with the advice and consent of the Senate, shall make treaties and shall appoint ambassadors and other public ministries, or ministers and consuls. Writing for the court in the 1936 U.S. v. Curtis Wright Export Court decision, Justice George Sutherland reasoned that the President has the sole power to negotiate treaties, although the President requires the Senate's advice and consent to complete them. In Curtis Wright, the Curtis Wright Export Court challenged an embargo President Franklin D. Roosevelt had imposed pursuant to a congressional delegation. Indicted for violating the embargo, Curtis Wright argued that Congress had impermissibly delegated a legislative power to the president when it granted the president power to impose the embargo. Writing for a 7-1 majority in favor of the government, Justice Sutherland posited that the national government's power in foreign relations is inherent. Consequently, the limits on Congress's ability to delegate power relating to domestic areas, Justice Sutherland reasoned, did not apply in the area of foreign affairs. Justice Sutherland stated the broad statement that the federal government can exercise no powers except those specifically enumerated in the Constitution, and such implied powers as are necessary and proper to carry into effect the enumerated powers, is categorically true only in respect to our internal affairs. As a result of the separation from Great Britain, the powers of external sovereignty passed from the Crown to the colonies in their collective and corporate capacity as the United States of America. The power to declare and wage war, to conclude peace, to make treaties, to maintain diplomatic relations with other sovereignties, if they had never been mentioned in the Constitution, would have been vested in the federal government as a necessary concomitance of nationality. In this vast external realm, with its important, complicated, delicate, and manifold problems, the president alone has the power to speak or listen as a representative of the nation. Okay. So deferred enforced departure comes from this. Interesting. I wonder what Supreme Court, there must have been Article 2, Section 1, Clause 1. What does the 8 mean? Paragraph 8 or something? Of the U.S. Constitution. Hey, Desi, I want to first and foremost say I love you. I know that the Israel-Palestine conflict is difficult, and I really appreciate your willingness to engage in debate. There are 16 million Jews. Okay. Deferred. I'm just so curious when this first started, when the president said, hey, actually, I can do this as part of my working with other countries. I can keep some people here. I'm curious when was the first DED? First time deferred enforced departure. Fact check. Oh, formerly called extended voluntary departure. Contents, page 3. In addition to EBS, there is another form of blanket relief from removal known as deferred enforced departure, formerly known as extended voluntary departure, EVD. DED is a temporary discretionary administrative stay of removal granted to aliens from designated countries. Unlike TPS, DED designation emanates from the president's constitutional powers to conduct foreign relations and has no statutory basis. DED was first used in 1990 and has been used a total of 5 times since. Okay, that's interesting. Let's throw that in here. First used in 1990, referred to then as extended voluntary departure, or EVD, and it's been used 5 times since. Currently, certain Liberian nationals are designated under DED. Okay. What is the date of this? Oh, this is as of 2018. Name redacted. Uh-oh. Congressional Research Service. Okay, just curious. Unlike TPS, which is authorized by statute, okay, and then deferred action. Ooh, the big guy. Deferred action for childhood arrivals. DACA is a program established in 2012 which permits certain individuals who were brought to the U.S. while under the age of 16 and who have resided continuously in the U.S. since June 15, 2007 to remain in the U.S. and work lawfully for at least 2 years, so long as they have no significant criminal record and have graduated high school or college or received a degree equivalent. Let's see. For individuals who were brought to the U.S. while under 16, who continuously resided in the U.S. Oh my god, I butchered that. Continuously resided in the U.S. since June 15th, 2007. Do you have to work to maintain DACA? As long as they have no significant right to remain in the U.S. and work lawfully. Oh no, I guess it just allows you to work. Allows you to remain in the U.S. and work lawfully for at least 2 years. And let's see. Who have no significant criminal record. Graduated high school or college, or received a degree equivalent. Does not confer any path to permanent legal status and requires renewal every 2 years. Requires renewal every 2 years. In 2017, the Trump administration attempted to end DACA, but the action was challenged in court. In June of 2020, the Supreme Court ruled that the administration's attempt to terminate the program was unlawful. Let's see. Trump's administration challenged DACA. Let's see. Attempted to end DACA in 2017. But in June 2020, the Supreme Court ruled this attempt unlawful. I wonder how DACA, where does the president's authority to do DACA come from? I'm curious how the Supreme Court upheld that. It would have been a conservative court too, right? Would it have been in 2020? When did the lady die? This is the current composition, right? I'm wondering if it was a piece of legislation. DACA? No, DACA was literally just an executive order. I'm just curious where it... I'm curious where the where the authority came from. I think, right? Wait, am I making this up? The U.S. immigration law. Sometimes all the process of being origin. The DREAM Act bill, which would have provided a pathway to permanent residency for undocumented immigrants brought to the United States, was considered by Congress in 2007, failed to overcome a bipartisan filibuster in the Senate. It was considered again in 2011. The bill passed the House, but did not get the 60 votes needed to overcome a Republican filibuster in the Senate. 2013, legislation had comprehensively reformed the immigration system, including allowing Dreamers permission to stay in the country. The Senate was not brought up to vote in the House. New York Times credits the failure of Congress to pass Dream Bill as the driver on a bonus nationwide DACA. Policies created after acknowledgement of Dreamers, young people had been largely raised in the U.S., and Dreamers gathering from the DREAM Act, a bill that aimed to grant legal status to young immigrants residing in the U.S. Relevant legislation. Do we do executive orders here? Immigration Act, relevant. Relevant government law? What would you call like an executive order? It's not legislation. Relevant government statute? What category has both executive orders under it and legislation? What broad category could we have there? Tyranny, good one. Legal shit. Relevant policy. Oh, I like that. Okay. Okay. So here we can do legislation. And here we can do executive orders. Okay. DACA is definitely worth investigating. I dated a woman who was on it a few years back. On DACA? She was on that DACA, smoking that DACA pack? President Barack Obama announced his policy. Okay. Supreme Court decision barring public schools from charging undocumented immigrant children tuition. A Supreme Court decision barring public schools from charging undocumented immigrant children tuition. Oh, that sounds... Bro, I bet there's... I'm so curious. Okay, executive orders, and we're going to have Supreme Court decisions. That sounds super interesting. Plyler v. Doe. This was in 1982. And DACA was 2000 what? $2012. Let's see. Okay. Let's see. In 2014, Obama announced his intention to expand DACA to make more people eligible, but in 2014, Texas and 25 other states, all the Republican governors, sued the U.S. District Court for the Southern District of Texas, asking the court to enjoin implementation of both the DACA expansion and deferred action for parents of Americans, a similar program. In December of 2015, Judge Andrew S. Hannon issued a preliminary injunction blocking the expansion from going into effect while the case Texas v. United States proceeded after progressing through the court system and equally divided. Supreme Court left the injunction in place without setting any precedent. Oof, that Merrick Garland miss. That 4-4 Supreme Court. Good job, McConnell. Violating our constitutional rights. Republican Party leaders denounced the DACA program as an abuse of executive power. Nearly all Republicans in the House, along with 3 Democrats, voted no to defund DACA. Point here is the president have authority to waive immigration laws. Okay, noticing that. Damn, that court didn't make any decision. This would be an interesting case to read. When are you going to Israel? Maybe Netanyahu talk. Yeah, I'll do that, okay? Let's see. United States v. Texas. 597 U.S. 2016. This means it was the 597th case in 2016 that the Supreme Court heard or ruled on or issued anything on, right? Like gave an action on? 457 U.S. Wait, it was 597? Oh, did I fuck this up? Or 579? It's the page? Okay. Let's see. Donald Trump rescinded the expansion to 2017. They'll continue to review the existence as a whole. Congress failed to act, and the time extension expired on March 5th, 2018, but 3 separate U.S. district courts ordered an injunction preventing the phase out of the DACA by the state on the likelihood that the rescinding was arbitrary and capricious under the Administrative Procedure Act. Arbitrary and capricious is a legal ruling wherein an appellate court determines that a previous ruling, appellate just means an appeals court, right? But a district, when you say the district court, a district court means, hold on, I need to remember the court structure. You have the Supreme Court. Right below the Supreme Court, you have the circuit courts. Your circuit courts are your final big courts of appeal before you go to the Supreme Court. And below the circuit courts, you have your district courts. Right? Or the trial courts in the U.S. federal judiciary. If something gets all the way to a state Supreme Court, and I don't like the state Supreme Court ruling, I think the state Supreme Court was unconstitutional. If you appeal a state Supreme Court decision, does that go to then a district court, or does that go to the federal Supreme Court, or what is chain for appealing to the Supreme Court? Imagine if a .gov page just tells me exactly what I need to know instead of... Only if you're appealing to federal constitutional law. Yeah, that's, I mean, I imagine that's what you would... For example, in Pennsylvania, it's common pleas superior, PA Supreme, and for federal, it's district, appellate, and U.S. Supreme Court. The PA Supreme Court appeals goes to the U.S. Supreme Court. Okay. Oh, every state might have a different like naming scheme or convention for their courts before their state Supreme Court, huh? And I guess if something is being appealed, if something's being appealed from a state Supreme Court, I imagine it would it always have to go to... Because you're challenging the constitutionality then of the constitution of the state, right? If you're saying, I don't like what my state Supreme Court is saying, you're saying, you have to be saying that it's an unconstitutional thing based on the federal constitution at that point. Okay, so you're never appealing a state Supreme Court to a district court or a circuit court, right? You're going to straight to the U.S. Supreme Court, right? Or can you go from the state Supreme Court through the federal bullshit next? How do you have green text in a plugin? I've got like a color plugin. Okay. Too dark a shade of green? It's perfect. Fuck you. Okay, so arbitrary and capricious is a legal ruling wherein an appellate court determines that a previous ruling is invalid because it was made on unreasonable grounds or without any proper consideration of circumstances. This is an extremely deferential standard. In administrative law, a government agency's resolution of a question of fact, when decided pursuant to an informal rulemaking under the Administrative Procedure Act, is reviewed on the arbitrary and capricious standard. The Administrative Procedure Act, enacted in 1946, governs the way in which administrative agencies of the federal government of the U.S. may propose and establish regulations, and it grants U.S. federal courts oversight over all agency actions. According to Hickman and Pierce, it is one of the most important pieces of U.S. administrative law and serves as a sort of constitution for U.S. admin law. The APA applies to both the federal executive departments and the independent agencies. U.S. the APA Bill of Rights for the hundreds of thousands of Americans whose affairs are controlled or regulated by federal government agencies. The text of the APA can be found under Title V of the U.S. Code, beginning at Section 500. Let's see. The APA requires that to set aside agency actions that are not subject to formal trial-like procedures, the court must conclude that the regulation is arbitrary and capricious, an abuse of discretion, or otherwise not in accordance with the law. Set aside agency actions that are not subject to formal trial-like procedure. Okay. However, Congress may further limit the scope of judicial review of agency actions by including such language in the authorizing statute. To set aside formal rulemaking or formal adjudication for which procedures are trial-like, a different standard of review allows courts to question whether agency actions more strongly. For such more formal actions, agency decisions must be supported by substantial evidence after the court reads the whole record, which can be thousands of pages long. Okay. More deferential to agencies than substantial arbitrary and capricious review allows agency decisions to stand as long as the agency gives a reasonable explanation for its decision based on the information that it had at the time. In contrast, the courts tend to look much harder at decisions resulting from trial-like procedures because they resemble actual trial court procedures, but Article 3 of the Constitution reserves the judicial powers for actual courts. Accordingly, courts are strict under the substantial evidence standard when agencies act like courts because being strict gives courts the final say, preventing agencies from using too much judicial power in violation of separation of powers. Okay. Interesting. Okay, so let's reread this now. Congress failed to act on the time extension expired on March 3rd. Okay. The government deferred implementation of this plan for 6 months to allow Congress time to pass the DREAM Act or some other legislative protection for undocumented migrants. Congress failed to act, and the time extension expired on March 5th, 2018, but 3 separate U.S. district courts ordered an injunction preventing the phase-out of the DACA by this date on the likelihood that the rescinding was arbitrary and capricious under the Administrative Procedure Act. So the APA, there is a standard called arbitrary and capricious, which is highly deferential, meaning that the agency is probably going to win unless you've got a really good reason to challenge what the agency's doing. Couldn't you challenge DACA on like constitutional grounds rather than like just trying to rescind it? Or would that be like that would have been a different process, I imagine, right? Where's Leon Law at? He was in chat. Or Pisco knows this. Separately, on August 31st, 2018, District Court Judge Andrew Hannon of the Southern District of Texas ruled the DACA as likely unconstitutional, but he let the program remain in place as litigation proceeded. Oh, interesting. Okay. Okay. A District Court Judge of the Southern District of Texas. So this is going to be a federal court, but not your circuit courts yet. So this is your federal court. The United States Southern District Court for the Southern District. Okay. The Supreme Court, ruling on June 18, 2020, on the 3 injunctions blocking the rescission of the DACA, affirmed that the reasoning given for the rescission was arbitrary and capricious under the APA, but did not rule on the merits of the DACA itself, nor prevent the government from issuing a new rescission. Oh. Huh. Is it... So who has standing to challenge DACA? Where did these cases start before? Well, it started with President Trump trying to rescind DACA. Oh, states probably can't challenge DACA because it's just immigration stuff, huh? Who would he challenge? He couldn't sue himself. US v. US? That's true. That's so interesting. So the federal government, the executive branch, gave itself the ability to do a thing. And then when it tried to not do the thing anymore, the Supreme Court was like, you can't not do the thing that you just did. Because you had a good reason for doing it, but you don't have a good reason to stop doing it. Basically. Interesting. Theoretically, the same thing could have happened under Obama. So Obama could theoretically have the power to enact DACA, and then Obama could say, actually, DACA is hella gay. I'm going to rescind it. And the Supreme Court would be like, well, you can do it, but you can't take it back now because your rationale is really stupid. And nobody else has standing to challenge federal immigration law. Okay, interesting. On January 20, 2021, President Joe Biden issued an executive order reinstating DACA. On July 16, 2021, Andrew Hannon ruled that the program was created in violation of the law and illegally implemented. Hannon, it's probably Hannon, not Hannon. Hannon, we're American. He barred the government from accepting new applications to the program, effectively canceling Biden's executive order. However, the ruling allows for immigrants currently protected by the program to keep their status and allow DACA renewals while the case goes through the appeals process. An appellate court in October 2022 affirmed that DACA is unlawful. The case was then returned to the same federal district court judge to consider whether a formal set of regulatory amendments promulgated by the Biden administration to codify DACA into federal regulations on October 31 made the program lawful. Hannon ruled that the codified form of DACA violated federal law. However, he maintained the status quo. Current DACA reference proceed with the state. And Jesus Christ, okay. Who would challenge? Couldn't Congress challenge the president? Or what would that case? What would that court case look like? Like, let's say that I think that DACA is unconstitutional. Who has standing to challenge? If they feel like that's not constitutional, like who is standing to challenge any executive order? Wait, can you challenge any Who has standing to challenge? No, of course you could. If I had an executive order, if I signed an executive order that said Texas, oh, so it's gonna have to, like if I did an executive order that said Texas has to change its state name to Dick Suckers, Texas probably has standing to file a lawsuit against me for an injunction and then to say, fuck you, this is bullshit. You can't make us change the name of our state. But if the executive order pertains to something that the federal government has plenary authority over, the states basically have to kick rocks. But what if the executive branch tries to take power from the Supreme Court or from the Congress? How do they challenge? Can the Congress sue the president? Maybe this is where the term constitutional crisis comes from. Does the government have a way to fight the executive branch if the executive branch just EOs shit into existence? Congress could pass a law? Yeah, but what if the president signs an executive order saying, no, I don't like that law? Oh, I guess then you impeach the president, then you would impeach, right? Wait, who is standing to challenge an executive order concerning federal power? Congressional standing to challenge executive action. Oh, Jesus. The past few years have seen the development of a new political weapon available to Congress in its efforts to curb the growing power of the executive branch of the federal government, the use of the federal courts to have executive action declared illegal. The plaintiffs in these suits are individual congressmen suing in their official capacities and bringing their high political visibility into the courtroom. The goal of the lawsuits, the restoration... Oh, because you would argue, what, in Congress, I'm an injured party because I'm losing my ability as a lawmaker to do anything? The goal of the lawsuits is the restoration of proper constitutional and political balance between the legislature. So it would be like AOC v. the United States federal government. The goal of the lawsuits, the restoration of a proper constitutional political balance. If none of these suits have the congressmen alleged that, in none of these have they alleged that the executive acts have injured them personally in any manner. Okay, hold on. Rather, the legislators have claimed injury as members of Congress. Oh, yeah, okay, yeah, Congress. Thus, the suits are brought by congressmen qua congressmen. As a class of congressmen. As a result, there would seem to be serious questions regarding their standing to sue in the federal courts to have the executive action declared illegal. The courts addressing the question have not reached uniform results. This comment will examine 4 such cases brought by congressmen challenging executive action. Following a short summary of the 4 decisions, congressional standing will be analyzed in light of the latest Supreme Court standing, or the latest Supreme Court standing requirements. This analysis will then be applied to the 4 cases. Finally, a different basis for congressional standing will be offered, one admittedly not in accord with current standing doctrine. Can somebody just tell me the answer? Who is the author of this, and what is the year of this paper? University of Pennsylvania Law Review, volume 122, 1366. What the fuck? Volume 122. Ugh. Really? 1973. Huh. Executive orders can be challenged. The ACLU successfully challenged Trump's EO remain in Mexico a few years ago. My guess is because somehow they're able to prove that they're a harmed party. The question I have is like one of standing, right? So if the federal government has the sole means of doing immigration policy, and then they enact immigration policy via executive order. Let's say right now the president says, well, I declare by executive order, we're going to allow 500 million Muslims to immigrate to the United States. And then who sues the president at that point? Like, how do you stop the president from doing that? The states can't. They don't have standing for, I don't think any individual citizen, and I don't think the states can have standing to sue for. But you have a check here, don't you? Your check would be impeachment, wouldn't it? But there must be a step between impeachment and I don't like your executive order, right? Right. Constitution challenge? It'd be tough. President has brought authority for foreign affairs, but impeachment probably. Huh. Congress has never sued as a group. Only individual congressmen can, though maybe Congress can do a class. Well, but in this, their congressmen are trying to sue as congressmen, not as injured individuals, but as injured people who are. Fuck, I don't want to read all this right now. Fuck, we're getting too deep into this. I'm already past 8 hours. Let me finish just this paper, and then we'll do more tomorrow. You just ruled that DAPA was ruled unconstitutional. Maybe look into that as an example. Well, I'm just more curious. Well, I don't think the Supreme Court did. I think that district judge did. So I don't even know what that means. But it sounds like you said it was unconstitutional, but he'll let it stay. I don't know what the fuck that means. I don't know. Okay. Nobody can challenge a president when the president is doing something they have the legal authority to do, full stop. Impeachment is the only option. Yeah, I guess. But does the president have the authority to do immigration law? I guess depending on where they're drawing their power from, they can do certain types of... Okay, let me finish this. Okay. Jesus, okay. Anyway, this action was challenged in court. In June of 2020, the Supreme Court ruled that the administration's attempt to terminate the program was unlawful. Wait, hold on. June 2020, the Supreme Court ruled that the administration's attempt to terminate the program was unlawful. The Trump administration tried to impose new limits on DACA, but this action was also challenged in court. A federal judge in New York ordered the administration to set aside the newly imposed limits. Separately, a federal judge in Texas ruled that DACA was unlawful and that no new first-time applicants should be accepted. In January 2021, President Biden issued a memorandum reaffirming the federal government's commitment to DACA and pledging to appeal the Texas ruling. Wait, so can new people apply to DACA right now? Is government accepting new DACA applicants? We will also continue to accept initial DACA requests, but in accordance with the district court's order, we will not process initial DACA requests. Oh, so nobody knows right now because they're waiting for after this federal judge ruled it illegal. Oof. DACA acceptance is currently on hold after a federal judge in Texas ruled it unlawful, though the federal government is still accepting applications. Who shut down the student debt executive order? For student debt, I believe for debt forgiveness, I think individual citizens had standing to sue the government. That was individual citizens that were suing for student loans, right? Claiming that they were harmed parties. No, it was the states. Was it the states? I thought it was challenged by individual citizens who were previous loan holders. I don't know. Okay. Humanitarian parole allows certain individuals to enter the U.S. even though they may not meet the definition of refugee and may not be eligible to immigrate through other channels. Parolees may be admitted temporarily for urgent humanitarian reasons or significant public benefit. What the fuck does that mean? Put this under refugees and asylum seekers, I guess. Well, wait, no, hold on. Put it under other forms. Spivmeister, thanks for 5 gifted subs. Oh yeah, it goes right under here, I guess. Makes sense. Okay. Missouri sued the federal government for student loan forgiveness being unconstitutional. How does Missouri have harm there? Missouri versus U.S. student loans. Fuck, I have to leave. In an effort to protect the Constitution and defend Missourians, announced today that the U.S. Supreme Court heard his challenge to the Biden administration. How? What is his standing? Or what is Missouri's standing? In an effort to protect the Constitution and defend at stake is more than 30 billion plus impact on the federal budget. The case poses a major separation of powers on the Constitution. Because of all the debt forgiveness, it's a huge like fiscal burden that all citizens and states will have to share. Maybe is that? Maybe. It was through loan servicing. Essentially, Missouri would lose out on student loan servicing contracts. They did it on behalf of the loan service providers for their state. If Biden did student loan forgiveness, wouldn't they get paid? There's no way that that debt is just like it disappears, right? I imagine that any individual party that holds student loan debt would have been paid by the federal government, right? That would be insane if not. It must have been. Okay. U.S. citizenship. Immigration. Okay. Path to citizenship. In order to qualify for U.S. citizenship through naturalization, an individual must have had lawful permanent resident status, a green card for at least 5 years, or 3 years if he or she obtained the green card through the U.S. citizen's spouse or through the Violence Against Women Act. Okay. Through U.S. citizen spouse or through the Violence Against Women Act. Okay, let's see. There are other exceptions, including but not limited to members of the U.S. military who serve in a time of war or declared hostilities. Applicants for U.S. citizenship must be at least 18 years old. Okay, wait, path citizenship, become a lawful permanent resident. Okay, and then must be at least 18 years old, demonstrate continuous residency, demonstrate good moral character, pass English and U.S. history and civics exams, with certain exceptions, pay an application fee, possible other requirements may apply. Okay. Good one. Oh, we did it. Okay. Okay. This is a decent, like, introduction to legal immigration. Is there, real quick, is there a way to, like, right-click and expand all or collapse all? What am I asking, guys? Expand all Obsidian. To expand all sections, open the command palette and then select unfold all headings and lists. What is the command palette? Highlight mode, indexing. Is this the command palette? Is it this thing? Unfold. Control P. Oh. Unfold all headings and lists. Ah. Control P. What about fold all headings? Fold more. Oh, and that does it. Oh, and I could probably do, you can put hotkeys for all these, huh? Wait, what the fuck is it folding there? Control P. Unfold all. Okay, cute. Okay. All right. So if we want, there's legislation and shit we can read about. I don't know if I'll even do that, but at least we write it down. Today we went through basically the immigration process, an overview of types of people that become immigrants. There's immigration goals. It's probably good to keep this in mind when we think of what is U.S. immigration supposed to do. Involved bodies. Probably should go near the policy. Actually, it should go above policy. Because these are our sources for immigration law and policy. Immigration goals, immigration process. Immigrant types. Legal refugees, illegal immigrants. Probably gonna axe this section completely. Because we've already got legal immigrants and refugees. Illegal immigrants. I might just do a section on illegal immigrants. Although that, I don't know if that makes sense because economics, political impact, culture, and crime might be included in all of these subsections, or all these other sections, I'm not sure. All right, okay. I love you guys. We'll be back tomorrow. We'll do memes and then more reading. Be careful. Ripperino, cappuccino, pappuccino, hoppuccino, moppuccino, dappuccino, cappuccino, appuccino, appuccino, my deuterinos. I'll catch you guys next streamerino. Be careful.